Settling debt is the process of negotiating with your creditors a payment less than the total amount owed. Oftentimes people feel that as a person who's struggling to pay your bills, that you're negotiating from a weaker position. After all, you owe money and likely aren't in a position to pay it. But think of it from the debt collector's view. They're trying to get money out of a person that likely doesn't have much money. No easy task. You have more leverage than you think in settling your debts. And in this video, I'm going to give you 3 strategies that can help you to get the lowest settlement possible. The first strategy has to deal with delinquent taxes and child support. Now, not all debt is created equal. Certain debts are given special treatment over other types. They're given priority. 2 types of debt that get priority over debts like credit card bills and medical debt are taxes and child support. While it's definitely no fun to owe delinquent taxes or to be behind on your child support payments, the fact that you owe these types of debts can be used in negotiating a lower settlement. The reason is, even if you were to get sued on the credit card debt and they got a judgment against you, the IRS and your child support will have priority and thus get paid first in any given wage garnishment situation. When a creditor understands the reality of the situation, they will be likely to take much less in the form of a settlement because they know it'll be a very long time before they get paid, if they ever get paid, anything at all, as they keep pushing for a higher amount. The second strategy is to know when the statute of limitations expires on your debt. If you owe someone money, there's only a set amount of time in which they can file a lawsuit against you. Here in Arizona, where I work, if you borrowed money from a person or a bank, including a credit card, and you had a written agreement in place, then the creditor has 6 years to file a lawsuit against you. If they don't, they're barred forever from doing so. This is known as the statute of limitations. The other day in my office, I had a couple come in, and they were showing me a recent letter they had received from a debt collector. The collection letter was for a very old debt, and the collection agency was offering to settle the debt for pennies on the dollar. The reason why they were willing to settle the debt for so little is because the statute of limitations had expired, and they could no longer sue the consumer to get the debt paid. However, that was not entirely clear just by reading the letter. If the statute of limitations has expired, in most instances you shouldn't pay the creditor a penny. The creditor slept on their rights and they could no longer sue you through the courts. There isn't much reason to pay them at all in those situations. However, if the statute of limitations has not yet expired, you should find out when it will expire, and then you can either wait it out or use that as leverage to get a lower settlement deal. After all, if the statute of limitations is near, the creditor will understand that if they don't get something from you now, they may be out of luck of getting anything out of you in the future. So, how do you know if the statute of limitations has expired? Here are 4 steps that will help you to know that. The first is, what kind of debt is it? Depending on what kind of obligation you have, there may be different statutes of limitation. For example, in some states, there's a shorter statute of limitations on an oral agreement as compared to an agreement that's in writing, like a contract. The second thing you need to look at is, what state do you live in? Each state has different statute of limitation periods for different types of debts. For instance, if you live in Arizona, come see me and I can help you determine what the applicable period is for your case. If you don't live in Arizona, you can Google the statute of limitations for your state and then contact an attorney to be sure. The third thing to look at is, when did you start calculating the time for the statute of limitations to expire? Now, this starts when the account goes into default and the creditor could have sued you. In most credit card cases, this is usually when the account is 30 to 60 days past due. The fourth thing to look at is, has the creditor filed a lawsuit? Once a creditor has filed a lawsuit, so long as the statute of limitations had not already expired, they have met the requirement. If they haven't, and 6 years has gone by, they are forever barred from suing you. The third strategy is, don't threaten bankruptcy. The idea behind threatening bankruptcy to your creditors makes sense. I mean, if you file for bankruptcy, they're likely going to get 0. And if they agree to settle, they may only get a small amount. But it's better than 0, right? The problem is, everybody threatens to file for bankruptcy when they're talking to debt collectors. While logically it makes sense to threaten it, it likely isn't going to influence the creditor to lower the settlement amount. They know that while everyone threatens bankruptcy, most will not file, so it isn't much of a motivator to take less on the deal. Your better option to settling your debt is to fully understand what things you have in your favor and use them to the fullest advantage. If you have any other questions on debt settlement, bankruptcy, or debt collection lawsuits, head on over to my website at consumerwarrior.com, where I have written over 400 articles. There's numerous videos. There's even an audio podcast that can walk you through these situations. Thanks for watching.